Canal de inglês, canal de inglês. Canal de inglês, canal de inglês.
E agora o canal de inglês, por favor.
Canal de inglês, teste no canal de inglês. Sim, ok. Deve estar, ok.
¿De la notarial? Sí, en Bulgaria, 17 y 18. No sé si no, no. No está en la no, ya está en la sí, por favor. Perdón. está a vir tudo junto.
Olha, muda de página.
Deixa estar agora. Portanto, vamos iniciar.
So let's now begin. We will have Adam Todt, President of the Council of the Notariates of the European Union. Let me thank you all for being here to attend this conference, talking about digital identity in the notarial exercise. This conference benefits from the organization of the Orange Notarials in partnership with the Council of Notariates of the European Council, and it's a hybrid conference. It's in person and virtual. So it's the first one in this format put together by the association. It is limited in terms of seats in the room. Let me start by thanking our guests. First, thank Dr. Rezende. He's not here. Oh, he's here. He's here. Sorry, you're wearing a mask, so it makes it trickier. Sitting right next to us, Professor Carlos Rezende. Thank you for coming. To the General Director of the Seal of Justice, Jorge Costa. To the representative of the General Counsel of the Bar of Lawyers, Isabel Cerqueira. Dear Inspector, hereby representing the General Inspector of the Justice Services, Dr. Ida Sofia Carreira Teixeira, to the Coordinator of the Unit of Support Planning, Strategies and International Relations of IRN, Dr. Wanda Mota, dear Coordinator of IRN, Dr. Claudia Santos, and to dear Justice Point of Contact, Dr. Paula Pot. Thank you for being with us. Thank you also for Dr. Filomena Reis Rosa and Jorge Batista da Silva, who will open this session. I will now give the floor to Dr. Adam Todt. He is a notary in Budapest since 1998, and he is the president of the Association of Notaries of Hungary since 2007. And I think that he's already here online.
Everybody, dear President Jorge Silva, dear Francisca Castro, dear colleagues, dear friends, muito bom dia a todos. First of all, I would like to thank you for your invitation and the organization of today's conference. I'm very happy that the CNUE, in the context of the European Notarial Network, activities contributes hand in hand with our members, the professional orders, to an evaluation at the notaries level, this time in Portugal, around the topics that are high on the agendas of the European Union and of the CNUE in Brussels. I would have loved to be with you all in Lisbon today, but unfortunately, I have to apologize that in my double capacity as national and European president this year, beside my duties as a notary, my agenda did not allow me to come. However, I'm very grateful and pleased that I have been given the opportunity to open your work and address you by means of the new technologies, the core of today's discussion, the subject of digital identity in the context of the notarial activity, hot topic at the moment at the level of the European institutions. Indeed, the European Commission published on the 3rd of June of this year a proposal for the revision of the EIDAS and EID regulation. This is an important piece of legislation which will impact the notariates. Consequently, the European Notariate follows the legislative process closely. This happens at CNUE level, in our working groups, in our political fora, such as the CNUE board and the General Assembly, but also at the level of our capitals, where the topics is analyzed attentively by all 22 national notariates. Today's conference is the proof that the Portuguese Ordem dos Notarios is fully connected to these activities and reflections, and we hope that the exchanges of good practices and ideas in this very high-level workshop will contribute to the technical capacity building and the best choices that the Portuguese notariate will opt for in order to facilitate the citizens and companies' life when they enter in cross-border legal relationships. According to the EU proposals, member states will offer citizens and businesses digital wallets that will be able to link their national digital identities with proof of other personal attributes. So are driving license, diplomas, bank account. These wallets may be provided by public authorities or by private entities, provided they are recognized by a member state. The new European digital identity wallets will enable all Europeans to access services online without having to use private identification methods or unnecessarily sharing personal data. How will these new digital wallets fit into the daily work of our notaries? What would be the potential of this innovation for the notarial profession? What safeguards should be put in place? And I also ask myself, before introducing new features, wouldn't it be a good idea to start by making EIDs available on a wider scale? As notaries of Europe, we propose an additional level of security to be implemented. This additional very high level of security would complement the existing high level of security under the EIDS regulation, with additional security measures such as video conferencing and also biometrics for the public sector, including notaries, and to link EIDs with the Digital Tools Directive. We also consider it necessary to remain extremely vigilant about the scope of application and the exclusion, and to ensure that national formal requirements for legal acts are not affected by the regulation. We are currently working at the CNUE in order to find a common position of all European notariates on this subject. I'm convinced that this exercise will be useful in view of the practical experiences of the European notariates. Highly secure electronic identification is of paramount importance, but we must also bear in mind its limitations. In particular, I would like to highlight the fact that for the time being, digital procedures based on electronic identification do not provide fully secure identification, nor do they provide certainty as to the capacity of the signatory and that he or she has given free and informed consent, or that the legal transaction has been set up in accordance with all legal requirements. Recently, in the context of the implementation of Directive 1151 of 2019, which provides for obligation for all member states to make the information of limited liability companies possible online, the issue of the identification of the founders has been and still is crucial. This directive also provides for the possibility for member states to consider mere electronic identification as insufficient, which may be supplemented by audiovisual means such as video conferencing. A significant number of member states have chosen the model of notarial company formation based on electronic identification combined with video conferencing. So Germany, Italy, the Czech Republic, Belgium, Austria, they were already in force in the later three countries. And I warmly welcome this approach. We have all experienced in our notarial practice that use of new technologies can contribute to offer a better service to the citizen. We do all agree that citizens and businesses should have a simple, resilient, and effective access to justice. And this is the direction in which the CNUE and its members have been working in the recent years. Notariates across Europe are actively developing technologies to simplify secure communication between notaries, public registers, and clients via electronic channels, and to provide their clients with efficient solutions for archiving their documents and for easy and secure access. During the COVID-19 pandemic, the CNUE member notariates continued to offer their services to their clients, being considered an essential public service of systemic importance during the lockdown. Practical solutions, such as the online power of attorney, were put in place to meet special needs during this period. Increasing digitalization of our activities is also accompanied by a growing cross-border context. Our citizens want to benefit from the digital world in the European Union without borders being an obstacle. At the CNUE, we are aware of these issues. That is why we have set up the European Notarial Network, which aims to facilitate cooperation between European notaries. The European Notarial Network provides all notaries in Europe with practical tools to facilitate the handling of their cross-border files. Let me cite some examples here, such as the European Authentication Map, or the interactive guides on the EU regulations on matrimonial property regimes and on registered partnerships. But Rau Radoy, the CNUE Secretary General, will present you in detail later on all these instruments. Instead of a conclusion, I would like to highlight the fact that, in my opinion, it is essential that the development of digital solutions in a cross-border context does not undermine legal certainty. Legal certainty and trust in digital world are essential. From the point of view of notaries, who for centuries are guardians of the legal certainty in the real world, it must be ensured that legal certainty and the quality of preventive control of legality within the judicial systems, as well as the reliability of public registers, so the commercial registers and land registers, will not be impaired by increased digitalization of cross-border cooperation. Trust must be carried into the digital world like we do it in the real world. That is why I welcome the organization of this conference today by our Portuguese colleagues. It is an excellent opportunity to share our practical experiences and use on how notaries ensure in Europe an efficient trust in the digital environment. I'm sure we will have a lot to learn from each other today. Dear colleagues, I thank you for your attention and wish you a fruitful discussion in today's conference. Obrigado.
Thank you, dear friend Adam Todd, for your brilliant presentation. Let me now give the floor to Dr. Filomena Gaspar Rosa. She has a degree in law and a master's in administrative law by the Faculty of Law of the University of Lisbon. Also a PhD in law and civil sciences in the same faculty in ENN. She made sure and was the head of the institutional international representation in this institute in international relations in cross-border projects in cooperative networks, highlighting participation in national activities of the Judicial European Network in civil and commercial contexts, and also following the European Land Register Association and a role as a national point of contact of the European Director of Land Register. She's also the president since 2018. So, Dr. Filomena, you have the floor.
Está ligado? Ok, obrigada. Bom dia.
Good morning. Dear President Adam Todd, dear President of Ordem dos Notários, Jorge Batista da Silva, dear Director General of Justice Policy, dear representatives, dear presidents of bars, of associations, dear speakers, dear notaries, ladies and gentlemen, good morning. Let me thank you for having me. And also for the honor that was granted to me that alongside the President of the Council of the Notariates of the European Union and also the President of Ordem dos Notários. This is a digital time. This is a time of information. We are going through the greatest revolution of history after the Industrial Revolution. Just like this one that has transformed the face of the planet socially, and also in terms of economy and ecological. And the digital era is transforming the world we live in. Technological progresses that we are witnessing lead us to question the way that we live, we work, we relate. Technology allows us to overcome borders of space and time. Digital, by default, is taking over our lives, changing our daily life, internationalizing our relationships, including work ones, and our conviviality that now knows no border, no constraints. This subject is very pertinent, and the European Union has been following carefully, just like Ursula von der Leyen said, and she highlighted in the conference of September 16, 2020, the importance of the digital, creating an electronic identity that would be safe. An identity, she said, in which we trust that any citizen can work whenever or wherever in Europe for paying taxes, to rent a bike, technology that will allow us to control the data that we share and the usage that we can make of it. Digital society stands as an engine of globalization, internationalization, commercial exchanges, and heritage, personal relations between different countries, different citizens, allowing us to foresee a reality that it's closer and closer when businesses happen on a global context by financial transactions that are immaterial. This new reality brings a great challenge to the states of identifying and implementing control mechanisms that allow to encompass all the global universe of transactions, keeping the legal security and the trust that we must make sure exists in terms of legal businesses. In our context, it's very important to talk about the attempt of a diploma that has been discussed of performing acts via video conference. Legal businesses such as public deeds and other authenticated acts, virtual, interactive with sound, image and data in real time. This new proposal of title by distance with new technologies is unavoidable in my view. This is an era dominated by the globalization, moved by the speed of the world of business that works worldwide, and it was quite accelerated by the pandemic. This necessity to dematerialize was never so urgent as when the world was in the contingency of continuing to work at home, under lockdown, isolated, socially afar. I love new technologies, so I'm very optimistic when addressing these possibilities, and I have no doubt that we'll attain this new way of working. But there are risks. There is criticism. Some of them have been addressed, such as the lack of guarantee in terms of the will and the capacity assessment, and also to determine the law to apply. In terms of the will, well, we can always question the possibilities of moral, physical cohesion, although moral cohesion could exist in person. We know that this means might bring added risks. But knowing that these risks do exist, we might have some mitigation measures. Without a definite answer, I would say that we can always count on the service of professionals of this area, notaries, solicitors, register officers, clerks, so that they can follow this video conference deed, preventing this kind of commuting. It's a bit, we are compromised, I know, but it makes it easier. The simultaneous view by all, or the monitoring by a professional at home of the person or in the office of the person who is the author of the deed. So I think that by using the best technology that can now distinguish if the person who is talking is alive or not, so there is a biometric recognition that it's valid, in depth, if we can get the best technology and if we adopt procedures making sure that the titulator can define his will with questions that are able to assess the state and will of the person, then we can make sure that these deeds might become a reality and might be done safely. Same thing about recording and other possibilities of warnings, reminding that this is a public officer and everything that happens in face of a public officer might be consisting of a crime because of false statements. This might be limited. For example, businesses, when there is real estate involved, the Portuguese law always applies, or with the necessary and mandatory choosing of the law applied by the parties. Well, we can look at European regulations and to determine the best way to limit said obstacles. And I don't think that we are not able to overcome these difficulties and to be a factor of progress as agents of change in this global path towards digitization. The role of the notaries building this path, this is the motto. And I wish you all great conferences, and I'm sure that we will get new ways of working, taking advantage of new technologies, providing faster, with more agility, all of those who come to us without losing sight of the demands of legal security of the deeds keeping the humanity of relations, even if they are set in technology. Thank you, Doctor, for your presentation. I'd like to give the floor to the President, Jorge Batista da Silva, with a degree in law in 2004, University of Michigan, and has a postgraduate in law and computer science at the same university. He is very interested and a lot of experience in technology. He started 2 startups in this area, managing digital identity and fintech. He was the vice president of the Association of Notaries between 2010 and 2011, and president of Association of Young Notaries between 2007 and 2008, and now he is the president of Orange Notarial since 2017. Doctor, please, you have the floor. Good morning, everyone. Once again, I would like to thank everyone here, all the entities hereby represented. I will not cite them because they have been mentioned, but this event was something that was born with a virtual nature. But I decided, because we are all exiting lockdown, we decided to do it in person. And let me take advantage to remove the mask at a day that nationwide we can all do it. Let me tell you that this type of events, and I've been in many since I became the president, maybe this is one of the less known solutions of European notaries that has to do with a cooperation for providing services throughout the EU, with a network of 22 countries where we help each other in the enforcement of cross-border legislation. That's why we are here today for an event of the European Notarial Network. The representatives of this network, if you don't know, and this will be explained throughout the day, they are the point of contact of different countries so that every day they can serve citizens in applying, enforcing the law. And in the European Union, that sometimes seems to be so distant. It's much more important for citizens than the efforts that we do from the institutional point of view in terms of European regulations. So, I think that cooperation must be the guiding principle of European integration, and so this type of projects, such as the European Notarial Network, will allow us all to solve our problems, thus evolving together. Circulation in the European area and businesses are helped by different agents of justice, including notaries, contributing for legal services supported in processes in which we must apply the internal law, of course, but also European regulation. So for a few years now, we were all facing, namely, for example, in the divisions per death, we got something that's a bit weird, which is application of the French law in a Portuguese notarial document from a Portuguese deed. This has been a challenge from a technical point of view because legal experts are used to work with their legislation of their country, and this challenge could only be won via cooperation and institutional support of colleagues from other countries. This practical exchange of knowledge via this network has allowed us to evolve together, but it has allowed that by meetings, seminars, conferences, we can find practical solutions to solve problems of citizens in their lives. The digital identity that we will debate here is something that, well, it was a thing before the pandemic, but now it became pivotal in the life of citizens. For this intervention, I will not extend on this because I'm sure that we have a lot of presentations that will be quite enlightening. But let me mention that the world, in terms of digital identity and formalization of legal business, didn't change that much. It just sped up the process that was irreversible. So the notaries were identified with their digital certificates before all entities, and they were already using digital identity even if they didn't realize. That allowed them to identify before third parties with their role of a notary. Despite it's not regulated in our status, it was almost like a digital white stamp whenever you use it to sign documents, namely in the inventory platform. Also, different public and private agents use digital devices, and the citizens have digital certificates in their identity card. It's for their authentication or the showing their digital identity, and also for legal abiding via a signature that. And we have also the digital key, and we have Portal de Justiça, where people can authenticate and, for example, or can use the land register online. This usage of mechanisms for dematerialized businesses, it's not recent, but a reality that existed, and it was used in times of social distance as a way to mitigate the barriers to travel. Legal professionals, particularly notaries, but also other agents of justice and members of different institutions who are here today, have already noticed that after the pandemic, that citizens who have enjoyed the advantages of dematerialization and digital tools are not willing to give them up, and something that seemed to be done gradually will have to be implemented quickly. However, I do not consider that the path for the challenge that we are facing, public and private agents, that we get every day on how can we accelerate digitization and dematerialization, will not have an answer that is purely technological. The truth is that technological solutions already existed before this pandemic with some maturity to them. And I don't believe that its usage is isolated usage or even together will allow to support or to mitigate the challenges that they will face either by checking identity and also digital transactions. If we were to think, for example, digital archiving processes, we had digital certification based on cryptographic techniques or blockchain. For signatures, we had the same digital certificates that we can combine with biometrics or even use them for the purpose of collecting evidence that generates evidences, and this is surpassing the usage of digital certificates because they allow us in real time to be able to check not just that the person who is before us is the one that we have identified in the database, but also that in a certain time showed her or his will. So the biometrics will become the future and a new way of signature that will overcome the traditional graphical representation of a signature or the usage of a cryptographic system for signatures. Consequently, the problem will not be in the development of technological solutions, but in their legal framework and in the training of citizens. Legal harmonization at European level is essentially based on the ENN regulation for electronic identification and trust services for electronic transactions, which to some extent has come to function as a guideline to the various states, and as we all know, it came before the pandemic. This regulation, on the one hand, put an end to the technological rigidity of legal accepted solutions, because previously the digital certification based in cryptographic techniques was the only accepted standard European-wide, but it came also to establish, and this is quite more important, a rule of equality and reciprocity by providing that the equivalent technological solutions should have equal legal value, namely as proof, regardless of the country that makes them available. So, firstly, regarding digital identity and means of signature based on qualified digital certificates, and this already allowed before the pandemic, as long as we would fulfill the rules of the regulations, to bind legally. But despite this progress, I do understand that much remains to be done because the circulation of legal documents within the European Union, even in digital format and complying with the rules of the regulation, still suffer many entropies, many obstacles. So we need the different states to move towards national laws that favor this evolution, namely via laws that systematize digital identity and legal binding that allow us to understand the way that we can all go forward with e-transactions. And this is very important for those who are responsible for titulating the contracts. Beyond the legislative barriers, there is also the process of paradigm change among citizens, because at the moment there is an impulse derived from the pandemic reality. It will be necessary to educate them about the consequences of the usage of these tools and the irreversibility of their actions, since what they do in the digital world does not only remain there, it will have consequences in the physical world. Citizens, when they use the digital world, do not realize the binding manners, and we now those type of intermediation, a set of services helped us to dematerialize and to keep our life going during the pandemic. But we have consumption credit of high value that might be done online and impulse buying, and people don't realize of the conditions of the credit itself and the consequences that might come in terms of heritage in time in case of default or failure to pay. So it's very important to have by the state and entities and public associations following the public interest that educate citizens, ending digital illiteracy. And this illiteracy was thought for promoting new technologies, but we need to think of it as a way to educate citizens in their transactional relationship with new technologies. Notaries must play a special role, and I'm going to toot my own horn because I'm the president of the Ordem dos Notários, but notaries must be a trusted, reliable interlocutor. For many citizens, trust them because it's them who are the intermediate for contracts. So they are the only agent of justice with whom they have spoken throughout their lives. The citizen, the common citizen, seldom goes to court and sometimes goes to registers, but they just do their small legal services, so they go to the notary because the notary has been there all their lives. And for this new digital reality, citizens will come to notaries as intermediates so that they can help them in this new reality. The issue and the question is, despite this hybrid event, we are here, fortunately, being followed by many people, European level and nationally. So the question is, are we ready for what's coming? I have no doubt in saying yes. As you will see today, the European notarial profession will monitor the process. People didn't realize, but this was a gradual thing. But a notary office, all of those things that happen are dematerialized, connection with registrars, with the authority. And this step of the dematerializing part of our procedures with citizens will be a natural step, and from the tech point of view is desirable. Citizens and this movement of simplification and the bureaucratization based on technology are not a future promise, but a reality that is present. But I must mention, and my dear friend spoke about this, the new law for virtual deeds, that I am the greatest supporter and also the greatest critic. It's a bit of a schizophrenic position, but let me explain. Virtual deeds are highly desirable in terms of simplification and debureaucratization. Ordem dos Notários was already working on this before the pandemic in terms of digital businesses. So this is no novelty, and soon we will have available a new digital archive of Ordem dos Notários and a permanent certificate that will provide all the archives, some of them decades old, where citizens can have an interaction and that it's fully virtual with the notary offices and also access this digital archive. The issue with this deeds is that in all sectors of our life, dematerialization such as banking was always gradual. We started by having access to reserved areas to access our bank accounts. Then little by little, we were able to get some interaction with our account managers, and now we can have some businesses such as opening bank accounts or credit to consumption. The problem lies in the fact that when we have a gradual processes, it is possible to educate citizens, telling them about the legal consequences of the acts that they perform in a dematerialized manner. But what's happening now is a different thing. It's a draft law that in an immediate manner allows that all legal businesses, namely a donation, can happen in a dematerialized manner, even with the mediation of a legal professional. All the technologies I went about, AI, biometrics, can do amazing things, but not checking identity. Checking identity and the verification of identity, let me tell you this. The machine is much more reliable checking identity than the human being. The truth is that the biometric elements are much faster to distinguish two twins than the human eye. This has been proved scientifically, and I can prove it. But there is no study that states this. And the verification of will has been developed by notaries, by conservators, by justices, and this was something that was developed based on what was their experience. No one finishes a law degree, learns how they can assess the will of a person, if they are being influenced, if they are sane. So this is something that we learn. We see if the person is nervous, if it is not. This experience gathered throughout centuries, it's of no use when we use them in a video conference. So, in my opinion, it should be wise to do it gradually. So, Ordem dos Notários advocates the dematerialization of deeds, sure, but they should start with acts that are unilateral. During the pandemic, for example, it was very useful for notaries and the citizens because the notaries never close, which is the list of heritage when someone dies. So there would be no problem of tomorrow starting to do these kinds of deeds per video conference. And if it's horizontal definition of a building, if the person is conditioned to its will, I don't see that this might condition it. If there is a purchase and sale agreement, because it's only by contract in Portugal, the conference is finished. So the truth is that we cannot understand or cannot assess coercion, if there was coercion or not. And those who are more vulnerable, victims of domestic abuse, the elders, if we think about the process of donation, it makes no sense to materialize immediately. Maybe in a few years, I don't know, depend on what happens with the other legal businesses. But this process of donation, and we all have been working on this for a few years, there are a lot of donations that are not finished because people are being coerced. We have people in front of us, and sometimes when we put them in the room with the children, with their children, only when they are alone can they say something. When they are at home or in a place that we don't know where they are, maybe they are being coerced or at least pressured by third-party elements. They have no way to protect themselves. So what I still think is that distance deeds will come to happen, sure. It's good for our economy that e-transactions come to be a reality, but we need to think that this evolution doesn't have to be, and nothing makes it be in the nomenclature in the world. It doesn't have to be at the same time. It can be gradual. So that's what we defend without the prejudice that we are public officers. So as soon as the law comes into force, we will do it the best we can, providing our citizens with our services. So the truth is, as pertains distance deeds, the notaries can be a partner of confidence of the state, and for citizens. So let me finish not just by thanking your presence, and also to those, because this became standard since COVID, of all of those who are watching from a distance. But let me finish by saying that legal professionals have an obligation before citizens. In that its extent, the technological evolution, as attractive as it might be, must be framed within the rights of citizens and not under temporary trends. I do believe that legal experts will be able to find a balanced solutions, making sure above all the public interest, the interest of citizens. Thank you.
Thank you for your brilliant presentation. Let's now proceed with the signing of a protocol that is quite relevant for our activity of the Portuguese notaries, which is the protocol to access the building, the simplified building information that will be signed by Jorge Batista Silva from the Notaries Bar. It will be enforced today, and it will be valid from today onwards.
Muito obrigada.
Thank you very much. Let's say that our daily life will now be simplified, isn't that right? It will be very much simplified, both for us and for the citizens. Following with our agenda, we will have now a representation of the European Network of Notaries by Raul Radoy, who is via Zoom. He has a degree in law and European studies from the Cluj University and has a master's degree in political science. Between 2007 and 2015, he was a counselor and a representative in Brussels, representing a national union from Romania between 2012 and 2016, and he is now the Secretary General of the CNOU EU. So, Raul, please, you have the floor. Thank you very much. Good morning.
Tudo ótimo, o nível do som. Bom dia, Vossas Excelências, representantes.
Good morning, dear representatives of the European associations, dear presidents, dear Filomena Gaspar Rosa and Jorge Silva, dear Francisca Castro, Vice President, who's also a member of the administration of the European Union Notaries Association, dear professors, magistrates, collaborators, and notaries, ladies and gentlemen. It's an honor, and I thank you for the invitation for speaking in this conference that talks about such a current subject. It's always a pleasure for me to speak for the Portuguese audience. Between 2002 and 2005, I worked in Lisbon, so I speak a little bit of Portuguese. I would like to be there with you today in Portugal. I miss Lisbon, but unfortunately it was not possible. Please allow me to say a few words about our organization, the Council of Notariates of the European Union. It is included within the topic of this conference, and it's a pleasure to thank all the colleagues for the organization of this conference within the topic of the European Notariates. It's not the Council of the Notariates of the European Union, it's a political order. It represents 22 associations of the European Union in their relationships with the European Union and their institutions, the Commission, the Parliament, and the Council. It cooperates with the institutions of the Union. They participate in the work groups on law, on legislation about the notariates profession. I would like to greet Paula Pot, who I always meet here in Brussels in the meetings that we hold and where we participate. And we promote the role of notariates towards the politicians and the audiences of the European Union that talk about the importance of justice. It also fosters the cooperation of the notary associations in their different technical domains, and it fosters that cooperation in several ways. This conference is an activity like that for me. In the last few years, the CNUI became the work, cross-border work that is becoming more and more relevant in the daily work of the members of the EU because of a growth of activities of citizens, families, and companies. for us to get closer to our topic, I propose you a small thought. You can see here some examples of public actions of the notaries, issued by notaries, on behalf of God, on behalf of the Republic. In its millennial history, the notary has always exercised public authority because he has a legacy power by the authorities in the domain of justice. The public structures of the notaries had the power to become law between parties in order to ensure the legality of transactions. So lex est quod notamus, so what we write becomes the law. That is the motto for many notaries in Europe. With time, things have evolved, and from the parchments, technology that became more and more important in the notary's activity, as in all sectors of society. And nowadays, notaries are issuing their documents in a digital format, even in some countries of the EU represented today in this conference. France, for example, Estonia, Lithuania, Belgium, here in Brussels. With COVID, with the pandemic, this became a need for solutions that were found by notaries. In other countries like Germany, the associations, the notaries associations, have registrations that are declared as public interest and manage many data centers in benefit of citizens and the society. The evolution from the past to the present is, but what will we have in the future? In this conference, we want digitalization, the digital identity, and the AI have a more important role to play. Using lines of code, I try to write here a metaphor within this context of the future of notariate. What it is for sure is the fact that in the future, the notary will write its data, its documents that will be connected to code. The code in an IT sense, they will be filed behind powerful algorithms. They will have a default digital way, and we will have a notion of having everything in a digital support, as it is already happening in several countries in terms of the law of societies. So quod est quod notamus, so we exist as the code. Maybe this is the equation of law safety in the future, law security in the future. Well, the notary will have a fundamental role to reduce so much interrogations on the digital future. So what is the contribution of the CNUE for the future-proof, prepared for the future within the context of the European Union? Allow me to speak now in English, because the limit of my Portuguese
knowledge in Portuguese language, and allow me please to switch to English. So the CNUE tries to support the notary in this context and to prepare the European individual notaries for more and more closer and interacting European Union and more digital. How does it contribute? By creating, first of all, we started a few years ago to create information websites for notaries and the citizens, which contain usually information on foreign law, and also by offering tools for the notaries, such as the European Notarial Network, which are meant to support them in their cross-border activity. I show you in this presentation a few examples of what we tried to do so far, and then, of course, talk about the European Notarial Network. Here are some examples of websites that the CNUE created, and you certainly know some of them. There are the famous websites on successions and matrimonial property regimes, but also a website on real estate law, and the protection of vulnerable adults and minors, and also more recently a website on the force of the authentic instruments in the European Union, probative value of the authentic instruments in the European Union. The Couples in Europe website is more actual than ever from the perspective of the application of the new regulations on matrimonial property regimes and registered partnerships, and here CNUE was prepared by providing information on foreign law for citizens and for the legal professionals via this website. The website is accessible in 22 official European Union languages and covers 28 European Union member states, and refers to the national legislation of these member states. Here you can see some examples of questions which are treated in this website. You will see that it goes quite deep in the substantive law of the member states in the field of family law, and also it treats problematics such as the applicable law, the competent authorities, and so on, so aspects related to the private international law. Another website, and we are very proud of it because this is in line with the political priorities of the European Union, is the protection of the vulnerable in Europe. Of the people with disabilities on the one hand, but also on the underage people. So we have created this website, and we adapted and we upgraded it last year in the framework of the European Notarial Network, because in a parenthesis, I would like to open a parenthesis. The information collected from the member states are collected with the help of the European Notarial Network. So we are always sending the questionnaires regarding this kind of information, collecting from the national level these answers with the help of the European Notarial Network colleagues. And of course, the working groups here in CNUE in Brussels refine this information and provide it to the public. It is a lot of work. We work for more than 10 years to create this information, to keep it up to date, to make it available in as many languages as possible. For the moment, the website, The Vulnerable in Europe, is available in 4 European languages, and it treats aspects such as the situation in which a person is confronted with a loss of capacity in the case of the adults, or situations in which a person would like to prepare a situation of potential situation of loss of capacity in the future. In order to promote the notarial service, the CNUE created also the European Notaries Directory, which is a database with the contacts of all notaries in Europe, including of those present today in this conference. On the other hand, besides this information, which is quite extensive and addressed also to the public, the CNUE created the European Notarial Network, which has multiple goals. It is, first of all, a network of interlocutors covering 22 EU countries with civil law notariates. And the main goal of this network is to provide mutual legal assistance. So this is a replica, if you want, in the notarial work of the European Judicial Network. What happens when a notary has a cross-border case or needs an information about foreign law, about European law? The network aims to be its first reference, its first point of contact in order to obtain this information. And this happens by the contribution of each and every national interlocutor, our colleagues from the member states, that give practical information and answers to the questions of the notary, and exchange with these notaries via electronic platform. And on the other hand, it occurs by providing information in an aggregated manner at European scale for the notaries to find the answers already in the European Notarial Network platform to their questions on foreign law or European Union law. Of course, the network is about contacts, about knowing people, about cooperating cross-borderly, and therefore we organize workshops in the framework of our meetings. And given this COVID pandemic, we were not able to come to meet in person in June in Lisbon during the Portuguese presidency of the Council of the European Union. We organized an online. Today, with the help of the Portuguese Chamber, we managed to have this conference, this very interesting conference in Lisbon. And this is in line with the activities of the European Notarial Network. Here you can see who are the people behind the network. These are the national interlocutors answering to the questions of notaries. You can see in the middle our coordinator, Giovanni Liotta, who is following us today from Italy, from Sicily. The European Notarial Network platform offers an online and secured multilingual and polyfunctional infrastructures for the notaries. First of all, communication tools in order for notaries to be able to overcome the language barriers and to get information on concrete legal case. This is a big challenge. And you will see how we will try to overcome this challenge. But it offers also legal information for notaries at European scale and practical tools for cross-border cases. There are more than 2,000 notaries currently in the platform, and you are very kindly invited to join this platform. This platform is accessible from any IT device, from a computer or from a mobile device. The communication amongst notaries and interlocutor occurs via the platform. So there is an inquiry environment, such as a mailbox, which is dedicated to this. Notaries can also see each other with the interlocutors and among themselves by video conferencing. We have a facility of video conferencing in this platform, and also communicate collectively via thematic forums and discuss various topics of law online, exchanging experiences in these forums. We have also developed the bilingual inquiry forms. But I will speak about them in a few minutes. Here you can see an example of an inquiry form. So a notary can join the platform and can use this form in order to contact the national interlocutor. You can see here I am, like a Romanian notary, asking a question about an issue of German law, and this issue This issue refers to the statute of the surviving spouse under the German law. So I'm asking here whether it is a statutory heir, the surviving spouse, and what is the share in the succession in case it comes to the succession alongside two descendants of the deceased person from a previous marriage. And this is a very specific notarial question in which a notary is dealing in a succession, with which the notary is dealing in a succession case. And I would address this question in case I'm a foreign notary and I'm interested in aspects related to German law. This question would go to the national interlocutor of the network, and then the interlocutor contacts the German notarial, the German interlocutor, who provides the precise answer with legislative references, with every information which is needed. That goes back to the notary that asks the question, and who can solve this, who can use this answer, this content in his or her file. Likewise, a notary can contact another notary via the platform, and this can occur via the forms, the so-called cross-check forms. We call them cross-check forms. For example, you have in front of you an example of such a cross-check form for powers of attorney. Notary can verify via the platform by filling in an online dynamic form, so directly on the platform, can inquire the notary who issued the power of attorney in another member states about elements from this power of attorney, or about elements regarding the revocation of the power of attorney. This is in the power of attorney in the notarial activity, in the cross-border notarial activity is the most, let's say, the most circulated document. And via the European Notarial Network, the notary who is receiving this power of attorney to use it for a specific transaction in the member states, let's say in Hungary, can ask the issuing notary, let's say in Portugal, elements about this power of attorney. And you have a form which is bilingual. The notary can fill it in. The Portuguese notary can fill it in Portuguese, and the Hungarian notary can read it in Hungarian, because it combines two languages, and it's not a translation, it's a predefined form. So you can ask a set of predefined questions. These questions were elaborated, of course, in the framework of the CNUE working groups and from the notarial practice all over Europe. Such questions refer, as I said, to revocation of powers of attorney or to other aspects. For example, the parties in an act, if they have capacity, etc., etc. So really aspects which are concrete in the notarial practice and which are, let's say, standardized in questions. The notary who is receiving these questions is ticking boxes or filling in concrete data, names, dates, etc., so that the other notary can read it back in this bilingual form when he or she is receiving the answer. This was not an easy exercise, I must confess, in the beginning, but for the user it should be quite practical, because this can be used in such a manner. What we also did on the same concept is the so-called passport for legal entities. This is also a bilingual form in which, for example, a notary from Portugal can issue this kind of passport that regroups elements regarding a company which is registered in Portugal and which he knows, and for which the Portuguese notary can obtain information from public registers or from his own archive, and the notary in Portugal issues this attestation about the company or about the representation rights of people in the company, and this is very important when a company is acting abroad, and the representative of this company can take this passport and use it abroad when opening a bank account, when creating a filial or a succursal, whatsoever. And in this passport, you have the notary can indicate the identity of the representative of the company and the extent of the rights of representation, which is for the bank that is going to meet this person quite important. The notary can, of course, use for this the certification levels that he or she can use in his national, according to his national law, and the company can wear this passport and, of course, accompanied with the annexes, with the excerpt of the registers, with the excerpt of the statute of the company, whatsoever, and can go abroad and use it in this manner. The passport can also be issued bilingually. For instance, if a Portuguese company would like to invest in Bulgaria, the notary will be able to issue this bilingually directly via the platform, or only to issue partial aspects if, for instance, only the representation rights are concerned, or only information about the companies and the shares, etc., are concerned in this thing. So, besides these communication tools that would allow getting and sending information from one country to another, in spite of the language barriers, the platform of the European Notarial Network makes available also information, for example, what documents are needed for in front of a foreign notary when dealing with a notarial procedure. For instance, with a succession. What documents do I, as a client, would need, or my client, which is a Romanian citizen, in front of a Portuguese notary that would debate a succession in Portugal. So I can see these elements. I can go prepared to the foreign notary, or my notary can prepare me while issuing these documents in order to ease the life of the foreign notary when dealing with the succession and when meeting me as a potential heir or as a potential having a cause in this succession. So this is another type of information. An example that I can give you here is about a database that we created and we upgrade quite often, which is the so-called authentication map in Europe. This is a database about the formal legal requirements requested for various acts, for 105 or 109 acts in the notarial activity in various fields, real estate, succession law, etc. And it is about the formal requirements in all the member states for this kind of acts and also for their powers of attorney. Why is this interesting? Because the notary which is issuing a power of attorney, for instance, for somebody to acquire real estate abroad, would not know what formal legal requirements are imposed by the law of this foreign country regarding this type of acts in order for the power of attorney to be valid. And you will see, in this case, I choose the simplest situation. The symmetry principle in the Belgian law requires for the power of attorney to have the same form as the main document. So in this case, in real estate law, what you see on the screen, it is authentic notarial deed, scritura publica, but there are situations in which, for example, a certified power of attorney would be valid for a real estate transaction for which in the state of destination public document is requested. So there is not always a symmetry, and the notary who is used with the symmetry of acts in his or her own country would not, would not guess from the start what form he or she would use for issuing this power of attorney for another country. Therefore, the notary has access to this information and can know from the beginning what is the formal legal requirement that he has to respect in order that this instrument be effective in a foreign country. Legal information, we provide, for instance, I spoke about the matrimonial property regimes regulation. We created, before they came into force, an instrument which is about to facilitate the understanding of this regulation. This is the interactive European regulation subsite of our platform. A notary can go and can have a look in the legislative instrument. The notary will have links to between the recitals and the articles, links to European Union case law, links to various bibliographic documents, to bibliography, etc. So this is an instrument to help the practitioner to apply and to understand better new legislation. We used it in the context of family law, matrimonial property regimes, and registered partnership. A field in which we also made available practical handbooks for notaries to explain the regulations by means of practical cases. Here you can see on the screen an example of the handbook in Portuguese about the matrimonial property regime regulation, and from 2016, which entered into application in 2019, and the notary was prepared 1 year before, if I'm not wrong, with this small handbook that provides practical cases for various situations in the regulation. Not only that, but the platform also offers the possibility for the notary to see how this regulation is applied in various member states and what are the elements of interference, let's say, between the European legislation and national legislation. This is particularly important when a new act is coming into application. And when, for instance, not all the internal legal architecture is adapted, or the adaptations are not yet known by the practitioner or not yet endorsed in a way in the practice. So this is where we explain, look, here in this situation, in this particular field, for instance, if we talk about successions and the possibility of registering in a public register of a foreign certificate of heir issued based on the succession regulation, well, we explain how the situation is in Germany, in Portugal, etc., according to the national legislation, because it might happen that in this legislative process in Brussels, when the member states negotiate these pieces of legislation, the fruit of the compromise is not always a precise let's say, in a precise enough text that that can be applied by the practitioners without additional acts that come and at national level, or without jurisprudence that would come at national level or European level to explain, to define what exactly the European dispositions intended or how they should be used in the national application. So these are very, very fine-tuning elements that the notaries can find in this tool that we provide. Each notary can log in autonomously to the platform. So just goes in the network website. Now we have a very nice and new website. It was done in the recent months and launched, and we are very proud of it. And of course, the notary can open an account on this website, fills in a registration form, receives a confirmation mail, and activates exactly when you make an Amazon account, you receive an activation mail, and you by means of this activation mail you can then log in into the platform. And each time, this is a very interesting thing, each time when you log into the platform you have to confirm with a PIN that you receive on mail in order to apply strict security for the access to this platform. So why? Because sometimes notaries use attachments and they have to be secured when they are asking questions to the national interlocutors. And of course, we have to take all security measures. The platform, of course, fulfills all requirements regarding data protection. So actually everything is secure, data protection proofed, and it can be used by the European notaries. We invite the Portuguese notaries to join in high numbers the platforms and to discover this universe of information and communication tools that we tried to create for them. Thank you very much for your attention. Muito obrigado e bom trabalho.
Muito obrigada, Raul, por ter feito.
Thank you very much, Raul, for making part of your presentation in Portuguese, something that you are proficient in Portuguese, and thank you for presenting many tools that are at reach for the European notaries, and sometimes our Portuguese notaries are not aware of their existence. Thank you very much, Raul. We will now have a coffee break for 20 minutes, and we will be back for the next presentation by André Vasconcelos on the Portuguese experience of the digital means of certification. Thank you very much.
Muito bem, vamos.
Let's now start the part of the digital means of identification with Dr. André Vasconcelos, professor and consultant to the Board of Directors for the Agency for Administrative Modernization, talking about the Portuguese experience. Please, Doctor, you have the floor.
Hoje venho partilhar.
I'm here to share with you our way in terms of digital identity in Portugal, sharing our experience and a vision to the future. Well, what we have been doing from the public point of view, I would focus on 2 or 3 landmarks in terms of identification and documents, starting with physical ID of documents up to the 70s, 80s, 90s. Started to have different documents in our wallets, and we got the digital version with a simple authentication with the user and password. The Portal das Finanças, for example, and in 2007 there was a push through within the scope of the citizen card. But notwithstanding, everyone today has a citizen card. The digital usage was and still is relatively low. There is a set of niche users, but some people face some difficulties because they don't have software or smart card reader. So in 2015 we updated the digital mobile key that I will present soon. This ecosystem is on top of the EcoGov, which is the different websites, portals, public and private, are able to delegate an authentication with citizen card, with a digital mobile key, with a certificate from notaries of other entities in this mechanism of authentication. And it happens. Then there are attributes for the public administration. We will talk about some of them. Citizen card, social security. They are provided to the citizen in this process of authentication that can deliver to the website or portal or the app where it is happening. So there is a set of attributes in this authentication. The citizen selects the citizen card, puts the PIN, the attributes are collected, and then it is authenticated. This is the visible part of it. This mechanism of authentication of Gov has different levels. Maybe the most relevant one is the one that it's used the most, as associated with citizen card, with a code sent by app or SMS. Then we have other levels, namely the digital key or an authentication via social media with a residual usage to it. All this ecosystem was optimized with our mobile ID. This key, this digital mobile key, was to enhance not just security and safety, but also usability. You had citizen card, it was very safe, but you try to put a mechanism that it's equally safe but easy to use, and the user needs to have a smartphone, and that's it. In terms of this mechanism, is supported on the European regulation of 014. This key might be requested in person or digitally, authentication.gov, or in the tax authority with codes that are sent via letter to the residence of the user. And we are working on different channels today. Authentication with a key is just as we saw with a citizen card. This is, for example, in the SNS, which is the NHS, actually in Portugal. And this can be used via an SMS or an app, and the code that changes every 5 minutes. And then we get the attributes. Therefore, I get authenticated in the National Health Service portal. This component, Authentication.gov, was very important for those entities that were already working with us, changing a parameter in the integration that existed. In 018, on top of this mean of authentication, which is a key, is the signature set on the European regulation from 014 with a remote signature, meaning that I don't need to have the certificate in a smart card or a drive. It is digitally controlled by the user. So this allows to sign with a digital key without needing anything else except for the smartphone to get the codes. I'm sure that you are users. You can sign in many apps with the digital mobile key. This is open for other entities. I will show you then many entities that started not just with authentication, but with proprietary signature apps. This is the signature of a document, the place where I want to sign, the PIN, the phone number, temporary code, and then here's the document signed. No need for readers, no need for smart cards. We have many other entities. Here you have the example of the first app in the realm of health, allowing physicians to solve a problem of prescription to domicile, because they had a problem when recipes started or medical prescription had to be handwritten. They had to bring that degree in order to send a paper prescription. Now they can sign it in the app using the digital mobile key. In the case of authentication, we have the example of some clients of ours. We have around 300 websites, portals, public and private, using the digital key. Not a lot of entities that are not using the digital key citizen card. This is an example in the tax authority, social security. We have many screens that I'm sure many of you have experienced in banking. Most of them allows the authentication with a key. We see some examples of BCP, Ativo Bank, Santander. There are some banks such as Santander or Novo Banco that not just authenticate. I can open an account, no video conference needed. How to do it in this authentication process is the necessary requirements, data from the citizen card, if I'm employed or not, the tax data, the address, 3 or 4 clicks, and the account is opened. This is data from the citizen, and the citizen conveys them to the bank. Caixa Geral de Depósitos, Novo Banco, as I said. Huawei, Banco Best, Bank Inter, some utilities, and telcos such as Mel and EDP. And this partnership with private entities became extremely important because typically the common citizen has a less than frequent interaction with the public administration. Depends, of course, 2, 3, 4, 5 times a year, tax authority, but not just. But if we extend this to private entities, in terms of home banking, 3 or 4 times a week, and they never forget the PIN because they are using it and they have the right PINs and they are familiarized with its usage. Also, the inflow excluded and inflow exclusion. We help citizens who wish to activate this key and to use public services with this key. This is a double screen, so the lady is doing her thing and the client is watching on this side. Sometimes the citizen can replicate what they learned. As I said, we've been getting a lot of acceptance from 2018. There was a change in scale, the number of enrollments per month. We have 2 million and something of active DMKs, and for many reasons, with the activation with Citizen Card, activation via the Tax Authority portal, which helped change the scale. We are convinced that soon we will change the scale again, and we will tell you why next. The usage of the TMK compared with other means, we are in a different scale since 2019. Three, 4 times more use than the Citizen Card, because the Citizen Card is very niche, or other certificates such as notaries and whatnot. Associated to this ecosystem of digital identity, we have the professional attributes. The basic idea here is that with the Citizen Card since 2007, and you can see the problem that my wallet is lighter. Instead of 5 documents, I have just 1. Some of them have disappeared, such as the elector number. But I have many professional papers, and I want to authenticate and to sign on those roles that I might have. So that's where professional attribute system came for, articulating between these different means of the TMK and the ones that have attributes, namely professional, association, or bars. So an accountant can authenticate and sign with this TMK or Citizen Card, and then there is an information coming from the bar of accountants that that accountant is properly certified. Some examples here. This is for public service. This is Diário da República, which is managed by Casa da Moeda. And because the nominations are published in Diário da República, in the Gazette of the Republic, it is sent to a database that is not structured, and when this happens, there is a process, a request, and a validation by the Casa da Moeda. The citizen gets this attribute and can use this to sign. I showed you one, but there are others. It's a signature that is similar, all in all, to what we saw before. If you were to see, here, on the bottom left corner, you see the attributes that can be selected. I can sign as a citizen, or I can add attributes to my signature. as a notary, an accountant, public officer, as a company administrator, etc. I select what I want to use, the citizen card, the DMK, and the signature is done. There is an interaction with the entity with this attribute, the Gazette of the Republic, with a confirmation before the entity and then a signature of the document. So the citizen only sees one signature, so if they see the detail, they see that there is their signature with the citizen card or the DMK, and then a second one of the entity certifying this attribute. Casa da Moeda or the professional association OBAR who holds this. In terms of professional attributes, administrators, managers, or proxies, there is a process of enrollment, given that this commercial register is not totally dematerialized, but there is a process or a procedure for manager or proxy and the powers associated with it. The law defines a set of current management signing, hiring agreements and contracts, post office sections. All of these duties are defined by the ENN, but there are other entities such as lawyers, solicitors, justices, and when you get this process of verification, the citizen is for 2 years, that's what's defined, or the proxy for 1 year, with the ability to sign under this quality, administrator, manager, or specific powers encompassed in the law, signing labor agreements and whatnot. They interact with the codes, with the entity that provided the codes, IRN, and then you get the signature here with the professional qualities of administrator, manager of the company X. These are some of the entities that we have in production today. I will try to read everything. Basically, we have a set of entities that have to do with local elected officers, mayors. We have others that are more specific in the military, for example, because the military use this. And then we have professional boards and associations such as accountants. The other subject that I would like to address is our e-wallet. The goal here is to bring into the physical world the digital. It's a bit different from others. We are talking about digital, everything digital. Here is in the real world, okay, to be able to use the digital. This was launched within the context of the Simplex program, our app id.gov.pt, with the legal support in the law 37 of 014, the article 44A, with the greatest support stating that it's the same, having the digital document or the physical document that's original, and it must be accepted in the different instances where the physical document. I'm not a legal expert, I'm a computer engineer, but if I wanted to sign a deed tomorrow, I would love to do with my EID tomorrow. Well, how does this work? It allows the citizens to input the attributes using the DMK. They are organized in cards. The cards that we had, a citizen card, driving license, and the public servant's health card. Now there are other 4, military, the car registration document, the employee identification card. Maybe we can talk about this if there's an interest in this issue. This app, the citizen selects the cards that they want to use, and then it's the same process as the DMK. PIN, smartphone, phone number, waits for a few seconds, the attributes are then returned, and then the citizen gets the card that he has selected. They have some mechanisms, like in the physical world, a physical document. You can vary the brightness, you can change the coat of arms, so this can be visible with the naked eye, a few seconds to understand if it's just a picture, if it's an app, or in sensitive areas we have the shield or the coat of arms on top of the picture. If you were to see there is a coat of arms, and these are the ones that we can see clearly. Then if I need a stronger certification, I can go to the server, to the entity, the IRN, the IMT, to identify. And this is done via a QR code and other documents, so car registration documents. So the QR code check is done by pressing on it, and the entity, this is with an officer of the law, he just uses a smartphone, and with a QR code for 5 minutes he can get the set of the data that the citizen is presenting, making sure that it is valid or not. So this is available with a code that you see here, some digits. That code might also be used in a desktop. Imagine that in your notary office you can certify it, thusly opening authentication.gov, you see the QR code, you copy it into this form, press OK, and you get exactly the same data. Sometimes using the smartphone is not that practical. So it's possible to export signed documents. These attributes of the citizen card, I can generate a PDF signed by the Portuguese state with that data. The example that I usually use is my account manager from Caixa Geral de Depósitos. She asked me to use the data because I haven't sent for 5 or 3 years updated documents, and I said I will send them to your email soon. I went to the app, generated a PDF signed by the state with my data, and sent it. It's the public administration that is conveying my data. So we want all of you to use this, to accept this type of innovation. Even police forces took their time to understand that they have to accept and to reorder their business processes, and sometimes there is one or other entity that refuses to accept. Well, it's a natural process of change, so we are working on it so that the citizen doesn't experience discomfort. In terms of the future, we have an European component within the European regulation, this so-called EDIS, and for the better part of the things that are seen here are therein supported. This regulation allows to have a cross-border authentication that doesn't have enough weight in Portugal yet. Our national infrastructure connected to other 17 or 16 member states, so there are some portals. For example, in the portal of ePortugal, it's possible to have some services. If I'm a Spanish citizen, I can go to this. I'm redirected to, I say that I'm Spanish, I'm redirected to the authentication.gov from Spain, and I use my DNI, and then I return to authenticate with the attributes that were requested to the portal of origin. This is one of the components that we must improve, making sure that we have more portals where this is available, portals that are public and private. If it's in European, I just select, for example, Austria. There's an example. And then I am in my Austrian environment. I can interpret this. I'm an Austrian citizen, and I input the code and follow the process of authentication, and then return to ePortugal properly authenticated. This is available, and we are very interested in bringing other entities to use it. There are some other things. Let me leave some of them. One of them, it's a QR code authentication. And then usability, we have some requests from a citizen that had to do all these things in authentication just to point the smartphone to the QR code. This is a different device where the citizen, after using the QR code, when he wishes to authenticate in a certain portal, he does the authentication and then it's done in the portal. It has to do with usability. We have also biometrics. We've replaced the second factor, the QR code, and the temporary code might not be input, and the user needs to open the app and input the smartphone and the PIN, and then to turn it to its face, or depending on the model of the smartphone. That's what happens here. We have a new mechanism. The others are available. This is not yet. We are just waiting for regulations. There are 2 Council of Ministers before the decree law was approved, the access to DMK with biometrics. If I have a smartphone, I download an app, I point the cell phone to my face, and then I will have the DMK. I don't need to get any letters, I don't need to go anywhere. As soon as we have the regulation associated, and we hope it happens soon, this will become possible. That's what happens here. I collect and I see if my citizen card is valid with the proper security measures. After I take a selfie, which is a video, actually. So it checks if I'm alive, and then we have some frames with a picture of low resolution in the citizen card in the first step, and the picture that we have in the database of the citizen card of high resolution. That's the main security device. So technology allows us to have a DMK without selecting the codes. We can get it via SMS, and that's it. We hope that this becomes available soon, and we are fully convinced that there will be a new boom in terms of usage as we had in 2018 and 2019 when DMK became available with a citizen card via Portal das Finanças, the tax authority, with a few hundreds per month for many hundreds, and we believe that it can happen again. Just to share with you our lessons learned, one that I have addressed is the reuse, because we have been getting partnerships with public and private entities, helping a lot so that there is an acceptance of the solution, because they use it, they need it, they are used to it and use it frequently. There was always a focus on the user experience, and the citizen card, this was not that perfect, mea culpa, but there was a focus on security, making sure that everyone had a digital identity, but then we didn't make sure that all of them could use it. This is a different thing. We want digital ID and we want people to use it. Mobile is a trend, undeniable. All these integrations are based on open standards. That's why we have 300 and something entities integrating with different technologies, no problem there. extending the digital ID benefits, not just partnerships with public and private services, allowing the citizen who deserves the effort that when they renew the citizen card, please activate the MK2. It's 10 more seconds, but it's worth it because they can go to home banking, they can renew the citizen card to pay taxes. So the subject of security is very important and it must be balanced with everything else. So the control that we try to give to the user, this is my last bullet point, where the user can check data, transactions, DMK. All of this is available via Authentication Gov, and you can see what type of signatures, apps. We will provide the data that were consulted in the public administration, data belonging to me. And that was all. Thank you.
Thank you very much for your energetic presentation that puzzled our translators. Everything is okay with them? Yeah. I will then open the floor for questions afterwards. Now I will give the floor to our friend Isidoro Calvidal, who's a notary in La Coruña. He is a notary whose activity is developed especially at an international level. He's the general counselor of the General Union of Notaries, and at the Spanish Association for European Matters. He's going to talk about practices of distance notary actions, and he's going to talk about the Spanish experience. He's going to explain a little bit of how it works and what are the best practices from Spain. Thank you very much. Thank you, Francesca. Good morning.
Pandemic, and it is a great pleasure for me to be in Lisbon again, sharing with you some reflections about the digitalization of the notarial function. I want expressly to thank European Notarial Network and Orden dos Notarios de Portugal for the kind invitation, and all of you for your presence here and by the remote media. The title of my presentation comes from my last book that I began to write last year during the lockdown. For me, it's an enormous honor to announce that a Portuguese version of it will be very soon on disposal, thanks to the initiative and the great job made by our colleague João Ricardo da Costa Meneses, Notario de Porto. This week, we have sent to the editor the last version, and this circumstance allows to me continue using the beautiful language of Luis de Camões or Fernando Pessoa. A direttiva 2000.
The Directive 2019-1151 of tools and digital processes in terms of social law of societies, it mandates member states to create societies completely online without the need of the parties to be in person facing any authority, person, organism authorized on the national level to take care of any aspect of the constitution, the online creation of societies, including the public deed of the creation of the company. However, according to the same directive, member states should allow their authorities and their competent bodies to verify via complementary identitary devices the credibility to create a society. These controls might include video conferencing or other online means that offer an audiovisual connection in real time. For that reason, despite the legislators of member states have committed to transpose the directive for their own internal regulations, it was unavoidable to question if this new scenario should be exclusively limited to the activity or the function of the notary in creating societies, or if once operated the change of the traditional schemes in the specific case could reach any other area of the intervention of the notaries, especially the real estate contracting or other businesses, law businesses on a personal nature, like a will or the vital will or the celebration of a marriage. Nor the legislative works nor the doctrine have reached any conclusion when the coronavirus COVID-19 pandemic caused the urgent imposition of new measures tending to make a compatibility of the lockdown measures with the continuity of the legal traffic and also the providing of notary services. Between the measures that were implemented in the member states, I would like to refer France or Estonia, and we should highlight the reforms also in Brazil. The implementation of new systems that go basically through avoiding the physical presence of the parties facing the notary even more justifies a reflection to analyze to which extent the assurances that are based on the notary service, how can they resist to this attack? As Camara, a Spanish master, said, the future of the notaries will depend on the capacity of the adaptation of the notary to the demands of these new times without losing the essence of their traditional performance. And this reflection should come from a central idea. It will be necessary to develop technology, complex technology that does not accommodate the action of the notary to what we are allowed by the technicality, but a technique should be developed to allow the notary to continue its action, although in an online environment, which involves the authenticity and the effects of the public instrument. One of the basic conceptions in where a public instrument is set in terms of the law security is the assurance by the notary of the identity of the people involved, as it will be shown in the following interventions today. The notary, taking into account the nature of the contract or the act and what is prescribed in the law in terms of the capacity of the person, should declare that, in his opinion, the parties have enough capacity to participate or to do that act or contract. The evaluation of the natural capacity as a general rule demands mediation between the parties as a notary perceives in the moment where it is done. It is this presence that allows the notary to investigate the circumstances of the person in each case, because it's the notary personally who has to issue a judgment, a law judgment, and to verify the conditions in which the party is presented to that action that is intended to be done, and he needs to ensure that it is valid and effective. The strictness applied by the notary in this field originated in our countries the existence of a jurisprudence that considers that the assurance given by the notary on the statement of the capacity has a special relevance of certainty that goes to a degree of a strong assumption that is binding, that can be just be broken by a judicial decision. The same rigor should be maintained in terms of remote situations. In distant situations, the mediation that may allow the notary to assess the parties will not find a better environment, and it will result better than a video conferencing or another online mean that allows an audiovisual connection in real time. The goal will always be to provide the notary the most appropriate conditions to assess directly and individually the circumstances and the real situation of each of the parties. As it happens with the causes that might define a change in the natural capacity of the persons, the verification of the assessment of the factors that might influence in each moment the consent also justify them to be object of a special attention in every new occasion, without being possible in any case to base that assessment from a previous happening on the exclusive basis of the assessment made in a previous action, as certain as it might be, as correct as it might be. The same approach is applied in remote or distance presence. In terms of remote or distance presence, and once again in a system based in video conferencing where the notary action can be better framed in order to verify and to conclude on the awareness and the free will of the parties. We could state that this new environment, you might have obscure areas out of the control of the notary where any intruder might condition a declaration of will or to force the consent. However, not even the physical presence assures the control by the notary of each circumstances that beyond the walls of the notary's office might influence a declaration. Despite the fact that preventive law says that the function of the notary is to reduce the existence of pathological situations in law transactions, it is impossible to fully avoid them. That's why judges and the courts have to solve those situations, reviewing all the elements of the transaction or the business in terms of contradictory law. To sum up, when the notary says that the consent of the parties was free, it's because it judged on its own responsibility the conditions of awareness and conscience of the parties. It reached a rational conclusion that it is like that. The informed will of the parties or the participants, together with legality, one of the essential elements that the execution of the public document should obey, regardless of the mean where it is contained, even if it is an electronic or a digital one. As a general rule, it's now common that when performing assessment and advisory works, after one or more meetings between the notary and the parties to verify what they need and to determine within that the most appropriate vehicle to fulfill the objectives, they should be complemented by new meetings to exchange opinions and to make available to the parties more or less developed advances of the instrument or of clauses through technological procedures that always assure confidentiality of transmission to the destination. The use of these instruments made possible to advise citizens when faced with a lockdown imposed to deal with the COVID-19 pandemic, when they chose to make with an hologram their will to create their succession, and the notary has facilitated that with that situation with creating minutes of the documents they should handwrite themselves. These instruments of incorporation of video conferencing or other online means that connect an audiovisual in real-time connection with the same goal will allow the notary to have the most appropriate conditions to understand directly and individually the circumstances and the intentions of each of the parties, and he will be able to advise, and which will culminate in the full reading of the public instrument when it's being notarized. In a presence environment, at distance or at remote presence, the two basic goals that are done with a qualified electronic signature, namely the guarantee of the identity of the signing party and the authenticity and the integrity of the data, are reached at a most elevated level by the intervention of the notary itself. The notary is the one who, acting in terms of the law, assures the identity and the legitimacy of the parties and ensures the integrity of the declarations of will, that regardless of the way they are made, even if it's an electronic, informatized or digital mean, they will always be registered on its public deed at the notary. The intervention of the notary allows the assurance of this electronic signature in the way it allows to ensure the use of that signature by its holder. Within this perspective, in my opinion, nothing would prevent the parties to use a level of electronic signature below the same signature that is qualified in order to sign an instrument that is authentic in the moment of its execution as authorized by the notary, always under his responsibility. One of the questions that is going to distance deeds also in Portugal, I think, because of what I've talked with the representatives of the Portuguese notariate, is the subject of territorial competence. The disposition according to which the creation online of a European company can be created in a cross-border basis excludes any possibility of imposing the demand of the parties to be localized within the limits of a certain notary area, even within the national territory, in case of the Republic of Portugal. This way, the application of a different solution for other deeds in presence or at distance without affecting the internal logic of the system, it seems complicated. Due to actions of legislative policies, if we considered as advisable to have special rules in the presence or this remote distance deeds, we should always keep the right of free choice of the notary to create criteria regarding the rational elements. When we are talking about considering the exercise of the notariate can be fully completed in the scenario where the physical presence facing the notary can be replaced by a remote or distance presence, or to reserve some areas for the traditional way of doing the public deeds, a fundamental premise should be taken into account. As the law does not make a distinction regarding the guarantees and the requisites for the intervention of any public document in the notary field, the digitalization of the notariate, it will only be possible in a way that those assurements and requisites can become fully fulfilled in the new environment. Thus, I'm inclined to state that besides limitations or strict reservations, the notary should be the one that, according to its prudent criteria and taking into account and assessing the circumstances of each specific case, should decide if the execution in hands should be made in presence of the parties through electronic means of communications at distance, or, on the other hand, it should demand the physical presence of the parties.
Taken in over the table by the European notariats recently, EUDOC. Taking into account our other notarial experiences as Bartolus or Eufides, nowadays we can present EUDOC as a fully operational and user-friendly application which combines three key functions. First, the secure exchange of electronic documents between European notaries, as EUDOC is provided with a security virtual private network to exchange documents. Second, a tool for the reliable identification or qualified electronic signature, including the notary status. And third, the direct interconnection between European notaries through private video conference rooms. EUDOC access is in line also with the EIDAS regulation. Thank you very much for your kind attention. Muito obrigado por a sua amável atenção.
Obrigada pela apresentação e pelo esforço em falar.
Thank you for the presentation and for your effort to speak Portuguese. I would now open the floor for questions to our speakers. I don't know if we have any questions.
Não? Faz favor, doutora Constança.
Sim. Portanto, os notários terão.
So the notaries will have to gather the elements of the citizen's card, either by copy or by the reading of by the card reader, to extract the deeds. How will we comply that with this new functionality? Well, it's not new, but sooner or later we will have to put it at work in our notaries. Thank you for your question. If I understood well, your doubt is how we can make the compatibility between documents used in ID.gov with the practice of the notaries and the need to gather proof of the documents that were presented. In terms of the ID.gov, the most obvious thing is to create a signed PDF in the app with the data from the citizen's card. The most obvious way will be that the citizen to create that signed PDF by the public administration and then to share with the notary, with whoever they need. I think that's the most obvious one, because with that signed document, that would be seen as proof. You can always use the QR code also to prove, as shown before, but I would say that is a little bit more complete. We are trying to develop some other solution that has to do with sharing directly some attributes with that phone you have ahead of you via Bluetooth or so. But in the current scenario, the most immediate situation would be asking the citizen to generate the PDF and to send it via email to have that proof. That's what happens in the procedures of opening a bank account when that happens. There is no sound on the booth right now. We will resume interpretation when we have sound.
Ou seja, o que é que está... Peço desculpa. Ok. Quem é que está...
Who are we leaving behind? What can and what should we do? The president of the association talked about his concern. The audio is being cut constantly. We cannot do interpretation with this microphone.
E grande desafio de todas as autoridades, de todas as entidades que têm obrigações legais, atrevo-me a dizer quase morais, no sentido de tentarmos também fazer aqui alguma harmonia, alguma coesão, a coesão territorial, geográfica, mas também social e de conhecimento e de informação. Porque eu próprio, eu não devia dizer isto, mas às vezes tem que se dizer as verdades, não sou grande literato nestas matérias.
I don't know a lot about this matter, but those who didn't have the privilege of being informed, I think we need to have this concern, specifically in the entities like the Association of Notaries, and the entities that at the state level have the need to take care of these matters, because this is the future. In terms of justice, we have a very strong plan that is the closest justice plans with the plans of innovation and introduction of new technologies in courts. But it is what it is. It was a time of great demand. The interpreters are very sorry, but with constant cuts in the microphone, it's impossible to provide a correct message of what is being said by the speaker.
Mas temos que nos preparar a começar, eu diria, a começar nas escolas, porque antigamente aprendia-se o A, o B, o C, 1, 2, 3, e hoje em dia nossos pequeninos têm que começar a aprender estas matérias das novas tecnologias e do digital, porque será um processo imparável. Muito obrigado.
Obrigado, Dr. Jorge.
Thank you very much. Yes, I do understand. I agree with everything you have just said. And we have a big problem there. Is how can these people have access even to social media? If we block access to social media, how can we do it so that they are not completely excluded? I'm like you. I'm not like Dr. Jorge, who's an expert. I feel sometimes excluded from all of these situations. I think we are moving too fast sometimes. Our population is a population that not all the population has access to smartphones. How can they manage the digital identity to go through third parties? There is someone who's impartial that might have some problems to access a bank account. For example, with the codes, how can we avoid the bank account to be used not by that person? Can that person have access to the account? But another person that might use it unlawfully. These are polemic issues that need to be dealt with, and the law needs to be changed. I thank you very much for your intervention. Thank you very much. I'm going to ask a couple of practical questions to our two speakers. The first one is for Raul Vidal, who I thank you by being here. And the question is, how will the Spanish notaries will prepare themselves, and what type of training is being prepared to show will through video conferencing? From my experience, it seems quite different from verifying the real will when people are in presence. And if the solutions are thought to have 360 degrees cameras, to have or not people in the environment of video conferencing, because all of this, even in Portugal and other member states of the EU, there are no rules on how to do that. We have banking experience where there is the prohibition of the intervention of third parties. You have proofs of liveliness where you can have that via video conferencing. I don't know if in Spain you have a kind of guidelines on how notaries should deal with that. To André Vasconcelos, I would ask a more technological question, that is, from the point of view of the administrative modernization, how do you intend to comply with the different entities? Throughout the years, we created different digital identities that are spread through different public and private entities. They have our data. We gave our data. It's true that the Chave Móvel Digital allowed to create an identity, but when will we have a law that will make comparing to recognize the civil identity that we had, that it was always recognized by the state, being that the entities that are recognized by the state itself, but we then have other private entities that manage the identities such as Google or Amazon. How could we have an European law like that?
Obrigado por a sua questão.
In the decree law of 28th of April of 2020, the legislator charged the executive power, the government, to mandate the development of the action of the function of the notary in the digital field. We are now widening the regulation proposal that is being developed by the government. Anyway, both when I planned the reflection of what could be tried for the new function, all this slowed down with the pandemic, but the digitalization came in the directive of the societies. We were doomed. And we came back from the meetings in Brussels. I always asked myself the same question. Are we going to keep this limited within societies? I can sign a deed, a public deed, to create a society in the morning, but in the afternoon to create a power of attorney, he has to come to my notary office? It makes no sense. So we need to develop tools that allow us, as I explained, to adjust not the action of the notary, the digital tools, but to adapt those tools to our mode of action and to keep the essence of our job. And dear Georgie, in specifically talking about the absence of threats, to assure that there are no threats, we are always concerned that people might have anything pointed at someone, something. But how many times did in physical presence we thought about if the party doesn't have the family in at home threatened to the person to give consent? It has always happened in physical presence. The Supreme Court in Spain, and I imagine that the Justice Court in Portugal as well, there are many judgments that annul public deeds because there was intimidation, threat, violence. From my point of view, the notary system, as in physical presence, as remote or distance, it will never be perfect. It needs to be as good as possible. And when there are flaws in providing the job, other means within the system, the judicial system, will be the ones that will provide the solution. I was completely skeptical when approaching this topic. I can say that as Saulo fell from the horse when going to Damascus, I fell from the horse when the pandemic told us that the world would move on, the economics and business would move on, and the notariat couldn't be left out of providing this job. I think we need to do a responsible study to see that in each moment of our job, the distance intervention is possible, and when it's not, when the notary has doubts that he can be performing his job in absolute awareness, because we always do it on our own responsibility, but our own responsibility means that our patrimonial responsibility, we will deny it as we do it in physical presence. We will deny it if we judge so. We, the notaries, have shown historically that we are able to accommodate our functions to the new circumstances, new tools in favor of our citizens and public powers, and this will be another occasion for doing that. I will respond to both the questions that were asked. The first one regarding the division of society between info excluded and the non-info excluded. My point is that these means are typically, or in the majority of cases, they are alternative means. The physical part still exists, so that will always be there for different situations. But it is a reality, and in Portugal, we are in the European and international rankings. We are typically very well positioned. We are leaders. We are in the top 3, top 5 in terms of making public services available. But in terms of users, we are on the other side of the table. So there is a problem of that division between the info excluded and the ones that are not. We have been working in that second part, in the use of the DMK is appropriate for any person who has a smartphone, internet, and is able to do it. But we have other people. We have been working with the citizen space and other public services other examples that I told you about, to bring the info-excluded citizens, to show them how to do those actions. We have been working with civil society as well, with Mood is an example. So it's a movement for the use of digital activities, where we did different actions to bring about people from different contexts, like with communication, dissemination, training in schools, in different places, with different ages, in order to reduce this digital gap. The topic of children is quite well incorporated in the curricula. Children already have that availability. My children, before speaking, they could touch the smartphone. So I think that in children, that's not that much of an issue, but that is an issue for other cases. But we need to move forward. We need to bring in the ones that are out. So the previous example of the pandemic of COVID showed that we need to have digital services. COVID helped bring a lot of people to the digital movement. I've noted that a lot in different situations. We see that in some public entities, schools, universities, all the juries became digital. In many other situations that happened, and that happened because the digital was there, or else we would have had a problem. It is a very important topic, and it's hard to deal with because it involves to evolve mentalities and skills that people didn't acquire when it would be easier to have acquired, and they are now, due to other reasons or for being older, it's more complicated to get those skills. But it's a work we have been doing, but we will always have some people that will need to be in presence and use the physical means. Regarding legal issues for the different entities that we have, as I said, I don't want to go in more or less legal way, but at an European level, namely at the AIDA's regulation. And we are starting a new discussion of the European regulation, because you already had a participation of Norbert or someone from the Commission who's very much involved in the process. That is a discussion that is happening not at the national but at an European level, to have an electronic digital identity that is at an European level. There is a perspective of a new European regulation to have an e-wallet, an European e-wallet. This vision of different identities is placed at a national level, but more and more at an international level, but needs to be supported by the national authorities. But there is an attempt to have this type of verification at an European level. But we have different countries, different sensitivities. But there is the proposal and to create an identity wallet to have at it at an European level. So that path of some changes at an European level was helped by the 2014 law, but I think that the one that is being discussed will also contribute for that purpose. Very well. I would say that we should have a pause for lunch just until 2:30. We will be back at 2:30 p.m. Have a good lunch, everyone.
Desculpe, o almoço é no bistrô aqui do hotel. É assim? Obrigada.
Estonia, each person receives a unique